Welcome back. We are starting the first ever seminar subsequent to our inaugural session which we have had in the morning. And for these seminars, we have two eminent experts in the field of patents, copyrights, and how one can boost these startups. So you would appreciate that in India, the IPR Act is not as strong as it is in US or in Europe. And in humor, one can say that in India, copyright is right to copy, unfortunately. And we have a few experts in that field. And definitely there is a positive transformation which is happening because of lot of legislations and rules which are getting induced in the ecosystem. And because of which the patents and the knowledge and the epicenter of that creativity will get properly preserved under some acts. So to talk about that, I will first request Mr. M.G. Kulkarni sir to please come on the dais. This seminar is being conducted by Kulkarni sir, and he will be talking about the areas of expertise which he strongly holds, that is in the areas of patents for innovators and entrepreneurs. So those innovators, those young scientists who would like to understand what patent means and how they can safeguard their creativity, here is the experts who will be coming. So he will invest 40-45 minutes to make us understand about all that, pros and cons and how to do about. And subsequent to the talk by Kulkarni sir, I will also have an opportunity along with you to hear to another experts, Mr. Nilesh Pavaskar. So can I request Nilesh Pavaskar also sir to come on the dais so that the audience will get to know. So the presentation first will happen logically by Kulkarni sir, which will take about 40 to 45 minutes. And as Nilesh sir suggested that let there be a no gap because Kulkarni sir will set the context and from there the Pavaskar sir will take it forward, right? So he may take 10 minutes to make us aware about how he can boost the entire ideations into the actual executions. So I will give a brief about both the experts so that there is a continuity of the presentation. I don't have to come in between. M.G. Kulkarni sir, he is PhD Tech, Polymer Science. He is a retired Deputy Director Head of Polymer Science and Engineering Division, NCL, National Chemical Laboratory, Pune. Some of the other areas of his expertise is like he is Emeritus Scientist for CiiA for 2013 to 2020, a long period. He is also among many meritorious acknowledgements, couple of them which I will take because of scarcity of the time, Young Associateship Award, and he is a Young Associate Chief of Indian Academy of Science. He is a fellow of many prestigious academic forums, bodies, nationally and internationally. So we have one of the very senior most person, all the way from Pune, he has come up to address all entrepreneurs and innovators. Can we have a round of applause for Mr. Kulkarni? Thank you, sir, for coming all the way from Pune. Then subsequent to that, after his speech, we will have Nilesh Pavaskar ji. He is a promoter of WEGO Library, W-E-G-O. Though I know I am not going to explain about what WEGO means because that is the experts will talk about. And you possibly would have also observed that there is a stall of WEGO in our exhibitions. So you have something to hear and something to see also. So he will take us through creating a research environment ecosystem for researchers to bring ideas to the laboratory. So from ideation bank to the executions or maybe at a prototype, he is going to tell us something about that. So please, I request Kulkarni sir to take up the session first. And once his session is over by 40-45 minutes, we will have Nilesh ji who can continue subsequently for 10 minutes. I request you to watch the presentation from down. And if at all there are any questions, the volunteers are there. We can move the cordless mic and we can have interactions also with the speakers. Okay? Please, sir.
Professor Joshi sir, Mr. Deshpande, Hemant sir, and my friends in the audience. Professor Joshi called me about 4 months ago asking me to give a talk on this occasion. And obviously, when Professor Joshi asks, one doesn't say no. So I immediately agreed. And while talking, he said, MJ, I know you for 50 years. And I was reflecting, and yes, I said yes. I first came in contact with him in 1972 when he was still doing his PhD. And since then, our association has continued. So it's almost 51 years that we have completed. It's also a pleasure to talk to the young innovators because you are the ones who are going to take this movement further. So what I'm going to talk to you about is a list of topics here. And you will see that this is a very long list, but we will briefly touch upon these. One can talk about each one of these for hours together, but that's not the purpose. The purpose of the talk is to brief you about the importance of the patents, what is a patent, why we need a patent, why patent system is there, and how patents are granted. And there are a lot of misconceptions amongst the people about what the patents are. So I'm going to talk a bit about it. And most importantly, for the young entrepreneurs, what precautions they should take when they are preparing to file a patent application. And some practical tips as what you should do and what you should not do, and then I will close my talk. So, historically we have read, that India was a very rich country. We exported spices to the world, and there was a lot of traffic, and we were a very rich country. And then suddenly things changed. So what happened? There were many countries in the world who had certain natural resources. And they derived their advantage in trade because of these natural resources. And this was called comparative advantage. They were at an advantage because they had certain resources given by the nature. And then came the Industrial Revolution, and then we read in the history books that India started exporting cotton to Britain, and then they made a fabric from that, and they imported back. We imported textiles from Britain. Similarly, we exported iron ore to Japan, and we imported steel from Japan. So countries who had these means of production, they became important. So that was the impact of the Industrial Revolution. Today, we are in a knowledge economy, and you will realize that the places where the goods are produced really don't matter. What matters is that who are the people who have the knowledge. For example, we all know, that Apple is one of the most successful companies in the world. But Apple doesn't make phones. All their phones are made by a company called Foxconn in China, and now they are coming into India. So there are a lot of such things. Most of the companies that we see their products, if you see Colgate toothpaste, Colgate only markets. Colgate doesn't make Colgate toothpaste. If you look at the toothpaste, down below there will be a small address which says who is the company who makes the toothpaste. So people who have the means of production are not important. People who have the knowledge, and that knowledge is protected by patents, is what matters. So I want to talk about, what is the magnitude of the problem? What kind of patents we have in the world today. So just want to give you an example from the US system. That first patent was granted to one Samuel Hopkins in July 31st, 1790, a process for making potash from saltpeter, which is mined. And from almost 1st of August 1790, to 8th of August 1900. In 110 years, 1 million patents were granted. And this 1 million patent was for making a tubeless tire with which we are all familiar. So 1 million patents were made in 110 years. And now if you look at June 19, 2018, 10 millionth patent was granted. And in March 11, 2021, 11 million patents. So 1 million patents were now granted in 3 years. So we are wondering from 11 million to 12 million in how many years we will go? Perhaps 2.5 years. So the speed at which people are patenting is increasing enormously because of the importance of patents. So as I said, US Patent Office granted something like 3.5 lakh patents. 3.5 lakh patents in 1 year last year, which meant almost 1730 patents every day. In contrast, the last number of the Indian patent was about 41,000. Now, this is changing very fast. According to the latest report, in 2022, we filed something like 65,000 applications. And this year, I just got a mail about last week which said this year we have filed 75,000 applications. So we are also catching up. So coming back, what is a patent? A patent is a techno-legal document for a competitive advantage. So what it means, this word technological, there has to be a technical advance. You must have done something which is technically not known earlier. So there is a technical advance, and that advance is of such a nature that it can be legally protected. So when you apply to the patent office and they grant you a patent, you get legal protection for the technical advance that you have made. Now the patenting process stops here, but that's not the purpose of the patent. Eventually the purpose of the patent is to exploit it commercially and make money. So it's very interesting, a good patent may not be a great invention. And a great invention may not be a good patent. So just to give you an example, Frederick Banting invented insulin. He discovered insulin, and for which he got Nobel Prize in the year 1923 for discovering insulin and elucidating the structure of insulin, which is such an important molecule today for the treatment of diabetes. But Frederick Banting did not get any patent because they said insulin existed in nature. So what have you done? You have obtained the structure, but nobody gives you a patent for trying to understand something. Generating knowledge, no patent. On the contrary, since the year 2000 to the year 2015, a company called Sanofi, which is based in Switzerland, got 70 patents on formulations of insulin. So insulin was known. What they have done is made formulations. So they got almost 70 patents on formulations of insulin. And they are global leaders. They have something like a product called Lantus, which is based on these patents, and these patents will expire sometime in 2031. So until then, nobody can make those formulations. So that is, making formulations is not as great as inventing, but invention did not get a patent, but formulations did. So that is what I mean by saying a great invention may not be a good patent. In fact, it so happens that most of the patents which are making a marginal improvement are commercially more successful than those which are really of a breakthrough type. Of course, those really great breakthrough, they do make money. But marginal inventions actually make. The other example was vitamin C. Linus Pauling showed applications of vitamin C, but Linus Pauling never got a patent. On the other hand, there is a company which we'll discuss a little later. What they made the invention? For our birthday parties and all that, we fill up balloons with water. And it's a painful process when you have to blow up so much balloons. So this guy made a device wherein you can fill in water in 100 balloons in 1 minute. And he got a patent for that, which made a business of $125 million every year. A patent also is a contract between the government and an inventor. So what happens when you go to the patent office actually represents the government. And for the invention that you make, after proper examination, if it meets the criteria of patentability, which we'll see little later, government gives you this award, which is called the grant of a patent. So this right is given to you in exchange of the disclosure that you have made. So when you are filing a patent application, you disclose what you have done and what are the boundaries of the invention. So in exchange of sharing this information with the public at large, the government grants you the patent rights. So it is what you would say a barter between you and the government. So to give you an idea, what you can patent products, you can process methods of doing something, making use of something. So what it does is, it gives you an exclusive right so that you can stop anybody who makes or sells or uses your invention territorially. Because now you realize patents are granted by the government. So if you get a patent from Indian Patent Office, jurisdiction is only India. So if you want to protect your invention in US, you have to file a US patent. Or if you want to want protection in Europe, then you file in patent in what is called European Union. So so it is geographically controlled. And the tenure of a patent, this right is given to you for 20 years from the date of application. What does a patent look like? A patent has a title, which tells you what the invention is about. Abstract, which gives you little more details. Then it tells you what is the area of the invention, which is covered in field of invention. Then you write what is the background of your invention. You know, what was it that people did in that area earlier. So now in the next section, which is summary of invention, you tell people what you have done, how it is improvement over what has been in the past. Because that is what prepares the ground for granting you a patent. Then of course you illustrate your invention with some figures, especially if it is engineering or chemical equations, etc., if it is a chemistry based. And then in the detailed description of the invention, you tell the people how this invention has to be carried out. Because as I'll tell you, the basic purpose of the patent is to disseminate information and knowledge so that society at large benefits. Because then people can read what you have done and do better than that and file new patents. So the purpose of the patent, or the whole reason why you have been given this exclusivity, is to disclose your invention to the public at large so they can improvise on it and the society benefits further. And the last is the claims, which actually forms the legal scope, what is the territory that is being covered by your invention. 3 types of patents. One is utility patent, so anything which serves some purpose. So it's a patent on a device, a process, how it works, a composition of a material, how to use a material. These are utility patents. Now the earlier outline that I showed you is for these utility patents. A design patent, on the other hand, doesn't need any of these things. It needs only a title and a figure which is illustrated with what those components are. Now why these design patents are there? Now you will be very surprised. We talked about Apple. Apple has more design patents than utility patents. So if you own an iPhone, you will see the contours of the mobile phone, the width, the depth, thickness, the curvature of the top glass, all these things, these are patented. Now there is no great invention, but it serves a purpose. So it is purely for the ornamental use. If you have seen an Adidas shoe or a Nike shoe, those letters are there in a particular way. Or the covering flaps. All these are patented. And there is a third variety which is called plant patent, which is for new varieties of crops. So you must have heard this brinjal and other varieties of seeds which are patent, cotton. So these are all patentable in US but not in India. So why do we need a patent? We need a patent to protect our invention. We want to exclude it from the market and create a monopoly so that we can make financial benefits. What is very important, especially for innovators like you, that even when you make an invention, you may not have the financial muscle to produce the goods. So to give you an example, a fellow came to me from Konkan last week and he said, I have made this product, which improves the performance of the diesel engines. So I said, what is the scale that you make? He said, I make 5 liters a day. I said, what is the market? He said, in Maharashtra alone 50,000 liters a day. Then I said, how are you going to do it? He says, I don't know. And this is a globally important product. It's very surprising. What he has done is the best, 10 times better than what best exists in the market today, which is a monopoly of a European company. So what can he do? He cannot manufacture in US, Europe, etc. So what can he do? He can license his patent to other companies who can manufacture, who will give them a royalty. That is how he will benefit. Also, when you see a patent, you know what are the boundaries of his invention. So you can invent around. So you can do the same thing in a way that he has not done and file. Now, patents are very important. Big companies, like Reliance, Hindustan Lever, they have a lot of capital, market, everything. But a startup has no capital. They don't have marketing strength. They don't have sales force. So what is the real capital they have? The real capital they have is their patents. And when the startups go through various phases of venture capital funding, the most important thing that the venture capitalists look at is what the patents you have. Even if you have an application, it is very important. So how does this system work? So you do some R&D, you develop a technology, you get a patent protection, you make investments in manufacturing, you produce the goods, you sell, you make profits, and part of it you put it back into the R&D and make new products, new patents. But imagine what would happen if there were no patents. The moment you start production and sales and you succeed in the marketplace, somebody will copy. Now you have no profits because there is competition. So all the investment that you have made is of no use. You can't exploit it commercially. So obviously you will not do any R&D because there is no incentive. Therefore, protecting the inventions of a innovator is very important, and that is what the patent system does. So the purpose of a patent system is to encourage the innovation, protect inventors' interest. If this was not there, then most of the inventions would have been trade secrets. So for example, we know, pharmaceutical industry is a big business. And they have the most important patents, the patents are most valuable to pharmaceutical industries. But that is all allopathy. Now we had these traditional medicines, Ayurveda, homeopathy, and I don't know the rest, but these are what I know. What happens? You go to a fellow, he gives you some pudi, and that's it. You don't know what is inside. And none of this is disclosed. So there is no dissemination of knowledge and improvisation. Of course, nowadays, based on the traditional knowledge, more patents are coming up. But they are not as at a level what the allopathic drugs are. So the purpose of this is, once you disseminate knowledge, the technology improves, the society benefits. And then there is wealth creation that we saw earlier. How does the system work? As I said, you disclose and somebody else improvises it. Then what happens to your rights? So I give this very simple example. I develop a composition which is shoe shine polish for a black shoe. And then you go ahead and develop a new composition which is colorless. Actually, they are there in the market. Now, can you market? You might get a patent, but you can't market because the original patent is mine. So you have to come to me and take a license. Can I copy your product and sell? No, because you have a patent. So it's a stalemate. So you have to take a license from me. And this may not work because I will ask for some royalty and the market for other types of shoes is not much. But what if I say that I have now taken that same shoe shine composition and shown that if you put it on the bald head, the hair grow, or the gray hair become black? Then there is enormous market. And you can charge anything. So now when you come to a license from me and I ask you for a fee, you will be very happy to pay. Now you will feel that this is a hypothetical example, but there is a real life example. That the drug in minoxidil was first developed for the treatment of blood pressure. And now minoxidil is actually used for hair growth. So, why we want patents? It is to encourage innovations. Now, what can we patent? Patent for that what is new. That is the novelty requirement. Something which is not known. But just being new is not enough. As per the novelty requirement, if there was a chair like this, and then I made another chair which was green in fabric, it was new because that was not known. But then this is not sufficient advancement, So, what newness you have done has to have a certain level of technical advancement. And that is covered in a criteria which is called non-obviousness. So, what you have done should not be obvious to the people. And that, of course, is a complicated area, so we will not go there into it. The next is, there is a requirement which says disclosure, and I always give an example. So imagine you go out into the villages and you find there is some piece of land which is lying idle. Now just because it belongs to nobody, of course when it belongs to nobody, it belongs to government. Can you just go and occupy? No, you have to pay and get a title for occupying that land. Now, can you get any amount of land? No, you will get only as much as you pay for. So, similarly, the scope of a patent in terms of claims depends on how much you have disclosed. So, that is a quid pro quo, barter between you. The more you disclose, the broader the claim the government will give you. If you disclose less, you will get a narrow claim. So what can be patented? So this is a very interesting cartoon where is this boy asks the girl, can I become your friend? She says, no, all my rights to the patents are with my other friend, Fritzster. Of course, this is the hypothetical situation. But what it tells you is that friendship is an abstract idea, so it cannot be patented. So there are other criteria like what exists already in the nature or laws of nature, gravity. Gravity is a law of nature. So you can't patent gravity. But if you design an elevator based on the laws of gravity, of course it is patentable. So we looked at all these criteria of patentability, which will not go into details. Now we come to the patenting myths, What is a myth? Myth is a belief which is not true. So, the first myth about the patent is the purpose is to get a patent. And actually, that is not. Getting a patent is not the end, it is actually the beginning. So how do we patent, and this is a cartoon from Alice in Wonderland, wherein Alice asks for the way and the cat says, where do you want to go? She says, it's immaterial, I will go. And he says, it doesn't matter which road you take, if you walk sufficiently, you will reach somewhere. Most of patents are like that. People don't understand why they are filing. So they get some patents, and so long as you file the criteria of patentability, patent office grants you a patent. But that doesn't mean commercially it will be successful. More myths about the patents. Patents are a must. Not always. You look at a business like McDonald's, Burger King, very successful, but they don't have a patent because their businesses don't need patents. Whereas inventions in highly science-based technologies, in pharmaceuticals, catalysis, petrochemicals, all these are highly science, they need patents. The second is, people always feel that if I get a patent, then I can practice it. That is not true. Patent gives you the right to exclude others, but does not automatically give you the rights. So what you have to do is to make out, go to a patent attorney like Karuna Madam and ask her, do I have the freedom to operate? So she will check whether by practicing your invention you are infringing somebody else's patent. And if not, then you have the freedom to operate and you can practice it. Then there is this myth called world patent. There is a patent cooperation treaty which is executed by WIPO, which again Karuna Madam represents. Under this system, you can file a patent application which you can subsequently file in other countries, which are about 160, I believe now. So when you file an application there, after 18 months it is published. And because it says WIPO, People feel it's a world patent. It is not. WIPO doesn't grant a patent. Similarly, when you file a patent application in any country, after 18 months it is automatically published. And people think that publication is the grant of a patent. It is not. I also said that the patent office life is 20 years. It is not automatic. That is the maximum life. So in US, at the end of 3.5 years, 7.5 years, 11 years, you have to pay renewal fees. If you don't pay the renewal fees, your patent lapses. In India, Europe, it is even worse. You have to pay renewal fees every year. Of course, you can pay fees in advance. But patents have to be maintained by paying maintenance fees. People feel patents are confidential. Patents are not confidential because it is published after 18 months, whether it was granted or not. But until 18 months, yes, they are confidential. Patents are high-tech and science-based. What has happened traditionally, it was all industrial. Patents are supposed to be for industrial art. Now, with the advancement of science and technology, we are becoming more and more science-based. And therefore, patents have become high-tech and science-based. But that is not a must. So, I'll give you a very interesting example. In 18th century, a very renowned scientist, Humphrey Davy, you must have studied this in your schools, developed what was called Davy's lamp. So what it did, it prevented accidents, fires in mines. So there was a poisonous gas and then it came in contact with the flame, it created fire. So he created wire mesh. And because of that, the gas would not reach the flame. So Davy was a very renowned scientist, fellow of the Royal Society and all. But by the time he discovered this, there was another person whose name was George Stephanopoulos. He invented the same thing, and this fellow was illiterate. In fact, he is the one who has developed railway engine. So, this fellow had no basics in science, but he could still invent the same thing which Davy invented. So, we'll look at another example where a very simple invention like balloons, as I told you, this was patented. So, the device includes a hose attachment with an opposite end, etc., etc. So, what it did essentially was it helped you to fill in 100 balloons in a minute. He got 5 US patents. And then it was copied by a company called Telebrands, which you must have seen on TV sometime. So when this was litigated in the court, they got a compensation of $31 million. The invention is very simple. How you fill water in balloons. So what you see at the top, that small yellow portion, if you can see it, that is the device that he invented and got a patent for. So we now see how people file, what precautions you should take when filing a patent application. Many a times, people do some research, and they want to file write a publication, they want to present a paper for the conference, and then somebody tells, okay, you have done this thing, why not file a patent? So you go and file a patent application. So you go to your patent office cell and say, so there is a rush, the patent offices always run against deadlines. So when you want to file the deadlines are met, but the quality of the invention is not great. In fact, the more innovative your invention is, more time you need to file a proper. Patent office will grant you a patent even otherwise, but then that is not a very powerful patent. Many a times, especially in academicians, I once met a professor, patenting is easy. What we do, publication that we are writing, we give it to the patent attorney and he files. Once again, as I said, you will get a patent, but that's not a good patent. Also, one of the, I won't say mistake, but when people are doing some research or they are trying to develop a new product or develop a new process, obviously for business reasons, they want to develop the best product. Fine-tune, make perfect. So all their efforts are spent doing that. And then they say, we want to file this. You can of course file, you will get a patent, but it has a very narrow scope. It can be invented around. So there is a special art as to how to do research with patents in mind, and that is the area of my expertise. So I help companies knowing their invention, how to what additional experiments to be carried out so that they get a broader scope of invention. So it depends on your objectives. If your objective is just to get a patent, you can get it. But if your objective is to commercially exploit and prevent your competition from getting into it, you have to think what all ways your competition can enter into area and block all those loopholes. So when patenting starts, most of the time, as I said, people do some research or companies take up a project, and after they complete the project, they say we want to file a patent. That is wrong. You have to start very early. As I said, patents are not granted for a product or a process. They eventually protect it. Patents are granted for an idea which is reduced to a practice. So the moment you have an idea and you know it works, then you should start thinking in how many ways this idea can be used. So there was one person I was working with, he developed an equipment which was for processing of waste plastics. And he said, I want to patent this. So I said, why are you doing this? Your equipment has lot of uses in pharmaceutical industry, in food industry, you can claim all this. But then he has to do those experiments and show that they work, and he can get a broader claim. So you must start very early, Now one thing, patenting is very easy because patenting is an open book exam. All the criteria that you must fulfill for the grant of a patent are already there. So it is an open book exam. So you need to know what are the rules and have your strategy for filing the patent application. So the most important is you must know why you are filing a patent application. Many people file because they want to show they have the numbers. That doesn't matter. Patent application is not a publication. It is not a science. Patents are granted for a useful art. First rule of writing a patent application is to say minimum things which are necessary. When we are writing a research paper, we write all sorts of things. Patent, you should not say one word more than what is necessary. And for that, what is necessary, you must know what is the purpose. Who is the patent addressed to? Now, if you ask this question, they will say, yeah, patent office, because they are granting patent. Patents are not for the patent office. That is only incidental. Patents have to be filed with your competition in mind, because he is the guy who wants to invent around. He wants to copy, because if your business is successful based on that idea, he wants to copy it. And when you sue him from infringement, he wants to show that your patent is invalid. So, when you are drafting a patent application, you must make sure that your competition cannot punch holes in your patent application. Patent office will grant, but tomorrow it gets invalidated, patent examiner doesn't lose anything, you are losing. So you must be always worried about your competition, and your patent must be drafted with your competition in mind. So there are, as I said, you have to follow certain do's and don'ts that we will see. We must plan early, must know what is the scope and what is it that we want to cover. Inventors always like to have very broad claims, and the examiner is trying to give you minimum possible. So I have seen many a times, I said, yes, if examiner is asking, I am narrowing the scope. Then the patentee says, no, I don't want to reduce. I said, look, your scope will be narrowed as far as the law is concerned, but in terms of your protecting your business, you are not losing anything. Then they are happy, because that is your purpose. Now, many a times you have to continuously do, because patents have to be maintained. So you have to make sure that you are commercially benefiting. Otherwise, you will only be paying the maintenance fees, and you are not making any money. So, over the entire life of the patent, you must continuously do the cost-benefit analysis to decide. And for this, you must continuously interact with your patent attorney, patent agent, your marketing team, and see how the business is changing. The reason why you have to be always interacting with patent attorney and agent is, you know what you want, but he knows how to put it in front of the patent office. So you need to know the purpose of the patent, know that it is not a publication. Meeting the criteria is not, oh, I'm sorry, this is repetition, so I'll skip. So how do you plan for a patent? You of course have an idea. Then you explore and see whether this idea is practical. So you will do some experiments to see, do some initial exploration if the idea works. If the idea works, then you want to see if it has failed, why it has failed, how you can convert it into success, how you can modify. And then you have to always interact, with your patent attorney to see continuously how to evolve the scope of your patent application. Then you have to decide which countries you want to file in, and you are not going to stop with one patent. One patent has no value. You need to create a portfolio. So you have to think, after filing this patent, what other things you are going to do. So you should not disclose in this something which you are going to do later. Otherwise, you have created a prior art. Now, why you want to do this? Do you want to only get a patent, or you want to have the freedom to operate, or you want both? All these issues, patent examiner will not think. You have to think. Most important is documenting the invention. That was one topic that I was asked to dwell upon. What is most important in patents is to write down everything that you have done. So when an idea strikes you, record the earliest date. So we call it what is called a black book. So everything that you do must be recorded there. And the researchers don't like it. They say, no, I'll first write on rough paper, then I will fair it. Not required. In whatever format you have, you scratch, it doesn't matter. But everything should be recorded in a black book. So one company that I was working with last week, and I said, let us start discussing. He says, no, let me first find out my black book. Because everything that I discuss with you, I have to write there. And he spent 15 minutes locating that black book. But without that, he will not talk to me. So you can describe your ideas, no matter in what form. It doesn't have to be very good English, but something which tells the reader that you had thought of this idea first. And these documents, they have to be witnessed by two people, saying with the day. Why it is necessary? We all feel, Alexander Graham Bell was the inventor of telephone. He was not. There were 4 people who stuck to the claim that they invented telephone first. But they had no records to prove that they had invented before Alexander Graham Bell. Graham Bell was the first person who had documented and got a patent. It is essential to establish the inventorship. If you record and later on somebody says that I published a paper, if you show that you had conceived the idea before the paper was published, then that publication doesn't damn your patent application. So all these things, and also if you have done later on, we are not going to go into infringement, but if somebody sues you for infringement, then you can show that I had thought of the idea first. So maintaining the record books is very important. Chronology of events, any alterations you don't have to scratch it. You can simply say, see later. This should be, as I said, attested by 2 people who know what you have done, but they are not the inventors themselves as a part of the patent application. And now, of course, there are electronic systems to maintain these record books. When you feel you have done your invention properly, you prepare a disclosure wherein you describe what is your invention and give it to the attorney. And that is called an invention disclosure. So what you need to do is to prepare an adequate disclosure of the invention prior to the day. So you have this meeting with the patent attorney. So you have to prepare this disclosure before the meeting. Be prepared as to what questions the attorney will ask. Then you must also mention there what is the best mode of carrying out your invention. This doesn't have to be a very lengthy document, but it has to be very precise and complete. And you have to present all the information related to the invention, because it helps the attorney to determine the scope of your invention and what should be your patent strategy in filing the invention. Where you want to file, because I said it's a territorial right. If you are happy protecting only in India, file. But if you feel your invention is so important, then you have to file in other countries, and Patent Cooperation Treaty, which is implemented by WIPO, is the best mechanism. Because if you want to file in all countries, you have a lot of expenditure and you don't know whether you will make money. So, under Patent Cooperation Treaty, you get almost 30 months, sum total. There are various steps, but from the first date of filing, you get 30 months to get into the national phases. So, your expenditure is split over a period, and you get lot of time to decide where to file. In fact, you can start negotiating businesses after you have filed application. And wherever you feel there are markets, you file, otherwise you don't file. Now, I always give an example, if you want to file in US is the largest market, and you file an application. You want to file in Portugal, very small country, but your costs of translating in Portuguese language are enormous. They are more than the cost of filing the patent. So you may not want to do that. So your decision as to where to file is based on what are the potential markets, what are the licensing opportunities, and what are the filing experience. As I said, PCT route gives you the best to buy the time. You must know what is the invention. And if there is one rule which says that one patent can have only one idea, if you have more ideas, you have to split it. And if you don't know, you can write, but the examiner will tell you that these are different ideas. And then he will tell you how to split it into different applications, which are called divisional applications. First, so this is what I say, if I want to draft a claim on a pen, then I say, yes, it has a metal body, that it has a clip, it is white, etc. It has a... That is the worst form, because we are focused on the pen that we have developed. If now you say, so what we have to do is to get out of this product and process mindset. What is a pen? It's a writing instrument. So instead of claiming a pen, I can claim a writing instrument, which includes a pencil, pen, ball pen, ink pen, gel pen, everything. Provided all these were not there in the prior art. So we have to always generalize our invention to get a broader depth of the claim. But that needs broader thinking. You must understand, most of the time what happens is, inventors, they write what they have done and hope to get. So they leave it to the examiner to decide what is the invention. But if you know what is your invention, you can file much better claims. In one case, I have spent 8 months in deciding what is the invention. The company had done all the work, but they didn't know what was the invention. And then we said, oh, this is the invention, and then they all agreed. So, very quickly when we run through the do's and don'ts, know the invention and its full scope, get out of the product and process box, do not disclose the invention to anyone, anywhere until the patent application is filed. This is my biggest worry. It is not followed very scrupulously in our country, but if you put a poster outside today mentioning what is your invention and later on you go to file a patent application, it can be thrown out. Of course, examiner doesn't know, but your competition will know. And he will say, oh, Kulkarni has filed an application, but before that he had put a poster there. Here is a photograph. You are gone. So what do? We can always file a provisional. Whenever an idea strikes, we can file a provisional application. Madam will discuss more details about it. And then you are free to disclose to anyone, no problem, because you have established your priority. Proper record keeping is very important, and most important, we must know why we are patenting. And you must have a commercial exploitation plan in place. Those plans may succeed, may not succeed, but you must have a plan. Most of the people do not have such a plan. I don't want to mention organizations, but there are many. They just file for sake of increasing the numbers. That doesn't give them any advantage. One patent, as I said, is not enough. You have to see how you can cover different aspects of the invention. So you create a portfolio of patents. I mentioned to you Sanofi in the beginning. On one product, insulin glargine, they have 70 patents. So they have covered various aspects of the patents in these 70 applications. So you have made such a tight fence that nobody can enter into your territory. You must have all such plans, otherwise other people will grab. So this is my last slide. What we have done is we have looked at what is the importance of patents in a knowledge economy. We saw that a patent is a techno-legal document meant for commercial exploitation. And the patent system is based on quid pro quo, which means apart from the fact that you are novel and non-obvious, the scope of the claims that you will get will depend on how much you are disclosing. There are a lot of myths, and therefore there is importance of educating everyone in this area. Patent system is meant for preserving the interest of all the stakeholders, inventors, public at large both. System encourages innovation and benefits all. It is very critical for the innovators and entrepreneurs because intellectual capital is the only capital that they have. Then we looked at how to prepare for patents. More specifically, we looked at what precautions we need to take. And as I said, ignoring patents can be risky. And therefore, we need to build an IP-savvy society. As I mentioned, the number of patents until now was very small, but in last 3 years, Indian Patent Office has seen a very huge increase in the number of applications in patents, which is a very good sign. I would thank you all for your attention, and I'll be happy to answer any questions you have.
Sir, please be seated. Please be seated. Please be seated. Thank you very much, Kulkarni sir. I must thank CiiA and Marathi Vignan Parishad. Firstly, CiiA to start the seminars in the 3rd edition of this kind of an event. And Marathi Vignan Parishad and in person Padma Bhushan Professor J.B. Joshi for creating an ideation of varieties of seminars and sessions, especially for all young innovators and entrepreneurs who are aspiring to be one of what Kulkarni sir has said. Sir, your session was enlightening, very methodical, and you give a very practical and apt example which conveys the message with full of a clarity. I remember Dr. Mashelkar was struggling to get the patent for a turmeric, and that was a long struggle which India did, and we got it. And today in US, the turmeric latte, which we call haldi dalke doodh, that is being sold at some dollars. So I think this session will tell about the importance of the application, which is more important than your ideations, because that carries the value. Like pen insulin of Sanofi fetches the patent and the copyrights than just the molecule of insulin. So thank you very much. And I request Professor J.P. Joshi sir to do the honors for the felicitation of our speaker, M.G. Kulkarni sir. There is a fruit basket, which generally from the MVP we do, and the appreciation through a certificate for his valuable inputs. Thank you. Thank you, sir. Now we will call upon the next speaker, Nilesh Pavaskarji. And as he had earlier suggested, the proper context setting is already done, right, Nileshji? And now he being a founder of Vego, he will talk about the execution part. And I am so thrilled to see that the patent attorney herself is here in this room. So this is not going to become a hall of culture, hall of knowledge, EP centers. And I am very happy that none of their experience and knowledge is patented. It is free. So you take advantage out of that. So thank you, Nilesh. You can take the charge. Nilesh Pavaskarji. He is a founder of Vego. And of course, you will definitely see a stall there where you will see the activities of Vego. And he is also a promoter. He is one line aspiration, which he always tells me since we met, is to create another Nalanda University. And I am keeping most of the points which he has to tell you with him only. And his topic for is to create a research environment ecosystem for researchers to bring ideas from the laboratory to the actual field. So I request Nilesh to take the charge. Thank you.
रामचंद्र की जय. CiiA. ज्या वेळेला CiiA हा शब्द माझ्या कानावर आला त्यावेळेला मला फक्त अयोध्या आठवत होती. आणि ती अयोध्या उभी राहिली फक्त संशोधनावरती. आणि कसलं संशोधन होतं तर प्रेमाचं. आणि हे प्रेम कोणाचं आपण नेहमी ऐकतो तर ते राधेचं असतं. आणि राधा म्हणते माझं प्रेम कृष्णावरचं इतकं युनिक आहे की त्याकरिता मला पेटंट हवं. आणि म्हणून आम्ही एक सुंदर लावणी लिहिली पेटंटची आणि ती यूट्यूबवरती अवेलेबल आहे. ज्यांना इंटरेस्ट असेल त्यांनी सर्च करून ती लावणी ऐकावी. आणि राधेच्या रूपामध्ये एक इनोव्हेटर कसं आपलं दुःख व्यक्त करतो किंवा आनंद व्यक्त करतो ही संकल्पना तुमच्या लक्षात येईल. आणि पुणे युनिव्हर्सिटीमध्ये आम्ही ती लॉन्च केली 350 इनोव्हेटर्सच्या समोर. आणि त्यानंतर एका तासाच्या लेक्चरनंतर मी सगळ्यांना विचारलं काय लक्षात राहिलं तर लावणीचे शब्द. त्यावेळेला माझ्या लक्षात आलं की पेटंट हा इतका वृक्ष विषय आहे की तो जर लोकांपर्यंत पोहोचवायचा असेल तर त्याला आपल्याला संगीताची जोड द्यावी लागेल. आणि संगीताच्या माध्यमातून आम्ही हे प्रबोधनाचं काम चालू केलं. विगो लायब्ररी फाउंडेशन 3 वर्षापूर्वी चालू झाली. तिचा मूळ उद्देश हाच होता की जास्तीत जास्त पेटंट या भारताला मिळाले पाहिजेत. जसं भक्त म्हणत असतो की माझी भक्तीचं अच्युत पॉइंट काय असेल तर मला देवाचा साक्षात्कार झाला, तसा इनोव्हेटरचा पेटंट मिळाल्यानंतरचा आनंद असतो. बऱ्यापैकी कुलकर्णी सरांनी कॉन्टॅक्ट सेट केला आहे त्यामुळे आपण जरा रन थ्रू फास्ट करू शकू. चायनाला 15 लाख पेटंट मिळाले गेल्या वर्षी. म्हणजे ॲप्लिकेशन झाले त्यावेळेला आपले 71,000 ॲप्लिकेशन होते. आणि त्यावेळेला सगळ्यात मला जास्त दुःख होतं की मी 71,000 पासून 15 लाखाला 2 वर्षात जाईन, 15 वर्षात जाईन की 5 वर्षात जाईन. तो रोडमॅप तयार करण्याची एक स्फूर्ती माझ्याकडे आली. आणि त्यानंतर 150 लोक एकत्र आम्ही येऊन ही फाउंडेशनची निर्मिती केली. एकच उद्देश होता की जर जापानने 1965 साली पेटंटमध्ये काम केलं त्यांचा GDP वाढला, 93 साली चायनाने काम केलं त्यांचा GDP वाढला, मग भारताने का नाही. आणि हे बघत असताना आम्ही थोडासा अभ्यास बघितला पाठीमागे. तर जेव्हा भारताकडे नॉलेज कॅपिटल होतं नालंदा आणि तक्षशिलेचं, भारताचा GDP खूप छान होता. हळूहळू ते नॉलेज कॅपिटल वेस्टकडे गेलं, कॅम्ब्रिजकडे आणि स्टॅनफर्डकडे. आणि भारताचा GDP कमी होत गेला म्हणण्यापेक्षा त्यांचा GDP वाढत गेला. थोडंसं अभ्यासाची गरज, पण इतकं काही वाईट नाही. आपण कुठे 81व्या इनोव्हेशन इंडेक्सला होतो. आज सकाळी स्पीकर्सनी सांगितलं की आपण चांगलं करतोय, 40 पर्यंत नंबर गेलाय, अजून पुढेही जाऊ शकेल. IPR बद्दल आपण ऐकलंच सरांचं. तर विगो लायब्ररी फाउंडेशन काय करते तर जी 5 स्टेजेस आहेत आपल्या पेटंट फायलिंगच्या, त्या 5ही स्टेजेसमध्ये तुम्हाला मदत करते. सो वी गिव्ह काउन्सिलर, we give patent attorney, we give sponsorship for the fees, and we make sure that we handhold you for 3 years to get the patent. तर थोडक्यात आम्ही लहान बहिणीचा रोल इनोव्हेटरचा बरोबर प्ले करतो. जी प्रसंगी आई वडिलांशी भांडते आणि भावासाठी सपोर्ट मागते, सासरला जाते आणि म्हणते माझा भाऊच ग्रेट आहे, त्याच्याशिवाय दुसरं कोणीच नाही. आणि दर भाऊबीजेला त्या भावाला सांगते की एक पेटंट घेऊन ये. याचबरोबर आमची सिस्टम खूप सिंपल आहे. एकदा ॲप्लिकेशन आलं ईमेलवरती, ते रेकमेंडेड असावं युनिव्हर्सिटीकडून किंवा कॉलेजकडून, की इमिजिएटली आम्ही पेटंट अटॉर्नी अपॉइंट करून देतो. अटॉर्नी NDA करून त्या इनोव्हेटरबरोबर नॉन डिस्क्लोजर ॲग्रीमेंट करतं, सगळं समजून घेतं आणि त्याच्यानंतर कामाला सुरुवात करते आणि आम्ही पैसे देऊन टाकतो. आमचा कॅटलिस्ट सारखा रोल आहे. आम्ही इनोव्हेशन काय केलं हे सुद्धा वाचत नाही, कारण नॉन डिस्क्लोजरच्या बद्दल कुलकर्णी सरांनी सांगितलं आहे. आणि आमची थर्ड पार्टी फाउंडेशन असल्यामुळे आम्ही इव्हॅल्युएट सुद्धा करत नाही. हे इव्हॅल्युएशनचं काम आम्ही कॉलेज आणि युनिव्हर्सिटीला सांगतो करायचं आणि त्यांच्या शब्दावरती विश्वास ठेवून आम्ही स्पॉन्सरशिप करतो. त्यानंतर सगळ्यात महत्त्वाचा भाग येतो की मी शिवाजी युनिव्हर्सिटीला होतो, त्यांच्याकडे 150 लाईव्ह पेटंट आहेत. पुणे युनिव्हर्सिटीकडे 100च्या पेक्षा जास्त आणि ICTकडे माझ्या मते मोठा ठेवा असेल, पण यातले किती कमर्शियलाइज होतात. म्हणून आम्ही एक डिपार्टमेंट चालू केलं किंवा एक विंग चालू केली ज्या माध्यमातून आपण पेटंट कमर्शियलायझेशनसाठी सुद्धा मदत करतो. आणि ही मदत वेगवेगळ्या रूपाने आपण करत असतो की अगदी त्यांना असं वाटलं की प्रोडक्ट कन्वर्ट करायचं आहे तर आपण ज्या असोसिएशन आहेत आयमा निमा किंवा ज्या मॅन्युफॅक्चर असोसिएशन आहे त्यांची मदत घेऊन ते प्रोडक्ट कमर्शियलाइज करायचा प्रयत्न करतो. अगदी त्यांना कुठे लायसन्सिंग करायचं असेल तर त्याकरिता आपण त्यांची जोड घालून देतो. आणि त्याकरिता आपले काही लोक पेटंट एक्सचेंज सुद्धा चालवतात जेणेकरून जे पेटंट केलेलं आहे अकॅडमिक्समध्ये किंवा इंडस्ट्रीसाठी त्याचं मॉनिटायझेशन जास्तीत जास्त व्हायला पाहिजे. यातूनच एक वाक्य आमच्या लक्षात आलं की युनिव्हर्सिटी शुड इनोव्हेट, MSME शुड मॅन्युफॅक्चर अँड देन वी विल हॅव मेक इन इंडिया. आमचा ऑब्जेक्टिव्ह एकदम सिंपल आहे, सिम्प्लिफाय करायचं, कोऑर्डिनेट करायचं, को अवेअरनेस करायचा, बस तयार करायचा आणि पेटंटमधून पैसा बनवायचा, एवढंच काम आमचं आहे. आणि त्याकरिता लोकांना तयार करायचं. हे करत असताना आम्ही एकही पैसा घेत नाही. तर वेल्थ कॉन्शियसनेस बद्दल बोलत असताना ज्या वेळेला आम्ही पेटंट हा मुद्दा सांगतो त्याच वेळेला अगदी साध्या अडाणी माणसाला विचारतो तो कृष्णा कॉन्शियसनेस खूप छान सांगू शकतो, पण वेल्थ कॉन्शियसनेस सांगणारा इंजिनियर मला सापडत नाही. आमच्या या 3 वर्षाच्या एफर्टचे विजिबल इफेक्ट्स आम्हाला दिसले. नाशिक सारख्या छोट्या गावात आम्ही काम करतो, तिथे MET फार्मसीचं छोटंसं कॉलेज आहे. तिथे आमचं पहिलं लेक्चर झालं आणि वर्षभरात आम्ही 6 पेटंट त्यांच्याकरिता करू शकलो. त्या 6 पेटंटपैकी एक पेटंट साऊथ कोरियन कंपनीने दत्तक घेतलं आणि त्यांचं जॉईंट व्हेंचर होऊन पुढचं काम चालू झालं. इतकंच काय तर पेटंटबद्दल सर्च जी गुगल सर्च आहे ती वाढलेली आहे गेल्या वर्षभरामध्ये. दिल्ली गव्हर्नमेंट थोडीशी टेक सॅव्ही असल्यामुळे त्यांनी खूप इनिशिएटिव्ह घेतला आणि गेल्या वर्षीच्या माझ्या मते 31,000 पेटंटपैकी 11,000 पेटंट एकट्या दिल्ली स्टेटकडे होते. तो इतकं दिल्लीमध्ये काम होत आहे. आम्ही 200 पेटंट महिन्याला सपोर्ट करतो त्यामध्ये स्पॉन्सरशिपमध्ये. आणि त्यानंतर सर्वात मोठी गोष्ट तर मोदी सरांनी तो विषय मनाला लावून घेतला आणि गेल्या वर्षी ज्या वेळेला सरांनी जय जवान जय किसान जय विज्ञान हा शब्द सांगितला त्याचबरोबर जय अनुसंधान हा शब्द बोलले. आणि जय अनुसंधानच्या माध्यमातून आज प्रत्येक युनिव्हर्सिटी जो मोदी सर ज्या वेळेला जातात त्यावेळेला पेटंटची चर्चा करतात. हे कदाचित आपल्या सगळ्यांच्या एफर्ट्सचं चळवळीचं यश म्हणता येईल. काही फोटोग्राफ्स तुमच्या रेफरन्ससाठी, त्यानंतर न्यूज कव्हरेज आणि सगळ्यात महत्त्वाचं गोष्ट जी आम्हाला वाटते ती म्हणजे रिसर्च जो आहे किंवा इनोव्हेशन आहे ते एथिकल झालं पाहिजे. म्हणून ही आम्ही एक छोटीशी ओथ तयार केली आणि प्रत्येक पेटंट वर्कशॉपमध्ये ती आम्ही ओथ घेत असतो. आणि मला असं वाटतं वेळ कमी आहे त्यामुळे तुम्ही वाचून घ्या, समजून घ्या किंवा फोटोग्राफ करून घ्या. या ओथच्या माध्यमातून आम्हाला एथिकल रिसर्चर तयार करायचे आहेत. आणि एकच वाक्य शेवटचं आम्ही सगळ्यांना सांगतोय की ज्या वेळेला तुमचं इनोव्हेशन पूर्ण व्हायला येईल आणि तुम्हाला असं वाटेल की आता मला पेटंट घ्यायला पाहिजे त्यावेळेला विगो लायब्ररी फाउंडेशन तुमच्याशी पूर्णपणे बरोबर असेल. आपण पुण्यात काम करतो, नाशिकमध्ये काम करतो, मुंबईत काम करतो, महाराष्ट्रात 3 ठिकाणी व्यवस्थित काम चालू आहे, दिल्लीतही काम करतो, कर्नाटकात काम करतो. 3 स्टेटमध्ये फुल फ्लेजेड आम्ही काम करत आहोत. कुठल्याही क्षणी तुम्ही आम्हाला फोन करू शकता. ऑफिस टाईम असं काही नाही आहे, 24 तास आम्ही अवेलेबल असतो कारण ही फाउंडेशन आहे. आणि ज्या वेळेला तुम्हाला त्याचं मार्गदर्शन लागेल मग कुठला काउन्सिलर तुमच्या शहरातला असेल तो मी आणून देणं, तुमचा अटॉर्नी तुमच्या शहरातला जवळचा आणून देणं आणि त्यानंतर त्या अटॉर्नीला लागणारे पैसे उभे करून देणं हे आम्ही काम करतो. धन्यवाद. इथे आमचा स्टॉल आहे, त्या स्टॉलवरती तुम्ही व्हिजिट करू शका. तिथे अटॉर्नी मोहिनी सूर्यवंशी आहेत, त्या तुम्हाला पुढचं मार्गदर्शन करतील. त्यानंतर जयंत ठोंबरे सर आणि स्मिता मॅडम आहेत ज्या काउन्सिलिंग करतात आणि तुमच्या प्रत्येक गोष्टीला डेप्थमध्ये सपोर्ट करू शकतात. तर अशी सगळी मंडळी आम्ही आहोत. मी स्वतः आहे आणि कसलीही गरज लागली, कुठेही लागली, जितक्या टाळ्या पडल्या तितके पेटंट मला इथे हवे आहेत. 101 लोक इथे स्टॉलवरती आहेत, त्यातले 12 स्टॉलचे म्हणजे 12 इनोव्हेशनचे आपण पेटंट ऑलरेडी केले आहेत बिफोर द एक्झिबिट. का तर एक्झिबिट होण्याच्या आधी ते पेटंट किंवा जे इनोव्हेशन आहे ते प्रोटेक्ट झालं पाहिजे. आणि कुठलीही युनिव्हर्सिटी किंवा कुठलाही बाप, मी बाप हा शब्द वापरतो, पैसे देत नाही कॉलेजच्या फीस शिवाय. तो म्हणतो पेटंटसाठी तर कधीच देणार नाही. तू आधी पहिलं कॉलेजला जा, नोकरीला लाग आणि मग तुझं काय ते बघून घे, माझ्या बरोबर झालंय म्हणून सांगतो. त्यामुळे तो बापाचा रोल लहान बहिणीच्या रूपामध्ये आपण करत आहोत. जोशी सर, धन्यवाद ऐकल्याबद्दल, आणि तुमच्या मार्गदर्शनाची खूप गरज आहे आणि या पुढची वाटचाल तुमच्या मार्गदर्शनाखाली व्हावी असं मी निवेदन करतो. धन्यवाद सर.
थँक्यू निलेशजी. खूप उत्स्फूर्त आणि उत्साही तुमचं ॲड्रेस होता आणि मला वाटतं की तुम्ही जी तुमची संवेदना आणि इच्छा व्यक्त केलीत की भारतातनं एक पेटंटचा हब व्हावं, इट शुड नॉट बी ओनली अ हब फॉर द मॅन्युफॅक्चरिंग, आणि त्याची हे नवीन युवा पिढी नक्कीच काळजी घेईल. आय रिक्वेस्ट प्रोफेसर जे.बी. जोशी सर टू डू द ऑनर्स अँड फेलिसिटेशन फॉर निलेश पावसकर, अँड थँक्यू सर फॉर युअर स्पीच. The certification also. Thank you. So looking at the time, which is the one very important aspect for these seminars, I suggest that we have the eminent speakers in form of Karuna ma'am. She is already here, patent attorney. So we will take only a 5-minute break so that ma'am can give the presentation. We will load it here and accordingly then we will take. So will you be in a position to take up now? So please. So welcome Advocate Karuna Goleria. I will give a brief introduction about her. We have here another epicenter of experience and knowledge in the field of patents, copyright, licenses, and that is something which is very important for all researchers and innovators to know about. Karuna ma'am carries more than 37 years of experience, maybe much more than the average age of innovators in the stalls. She is a graduate from Mumbai. She has done her LLB and LLM both from Mumbai University. She is a gold medalist from CiiA College, Mumbai. She owns her IP firm, intellectual property related firms. She is being seen as one of the authority, as Mr. Kulkarni sir also was talking about, referring her during his speech, experts in the area of intellectual property rights, copyrights, trademarks, patents. So she is who's who in the area, and she is also an authority being an attorney for that. She is being recognized by WIPO, as the earlier speaker referred to. WIPO stands for World Intellectual Property Organizations. She has attended numerous numbers of international conferences and seminars. So we have an authority here. So I take less of a time and more for the experts to talk about. And I request Karuna ma'am to take the session, please.
And thank you CiiA and Marathi Vignan Parishad. त्यांनी मला हा चान्स दिला तुम्हा सगळ्यांना भेटायला आणि सांगायला. माझ्या आधी 2 स्पीकर त्यांनी कुलकर्णी सर आणि निलेश सर, दे हैड सेट द माहौल बना दिया कि हाउ द पैटेंट, व्हाई इट इज सो इम्पॉर्टेंट एंड व्हाट इज इट, द बेसिक्स दे हैव very nicely and elaborately told. What I'm going to tell you today is how to get the patent, the patenting process, the practical aspect of getting a patent. My topic, as it says, it is IPR, so I'll be briefly telling you about the types of IPR, then patenting process elaborately, and the cost for filing patent application. So the types of IPR, broadly speaking, are patents, designs. In India, we have design registration. We don't call it design patent like in US. And what I'm going to talk is only pertaining to India. I may touch upon the international application, but the laws which I'm going to tell, or the practical procedure, it pertains to Indian Patent Office, Indian patent law. The third IPR is trademarks, geographical indications, copyrights, and semiconductor layout designs. The Patent as defined under the Act merely says that the patent for any invention granted under the Patents Act. More than that, it doesn't talk. So then we go to the definition of invention. What exactly is meant by invention? It means a new product or process involving an inventive step and capable of industrial application. So you get 3 eligibility criteria. It has to be new, that is novelty aspect. It has to be inventive. So inventive step, and it should have a utility. If you lack any of these 3 eligibility criteria, you will not get a patent. Then we speak of designs. Design could be that design of, say, this microphone, this speaker. What the definition says, it means only the features of shape, configuration, pattern, ornament, or composition of lines or colors applied to any article, and that article could be sold separately and which could be solely judged by the eye. So what is inside, even if it is decorative, the wire, you will not get design protection. Whatever can be seen from outside, this shape of this chair or bottle, you can seek design registration for it. As earlier stated by earlier speaker, there is no functional feature to it. It doesn't have to be beautiful also, but it must have an appeal to the eye. It should appeal to the eye. The criteria is not that an ugly thing you will not get a design registration, but naturally when you are trying to sell a product, it has to be aesthetically appealable. The next, the term of design is 10 years, and which can be extended to 5 years. Term of patents, as everybody knows, is 20 years. Trademark, which everybody is aware of, brands. Even the small child wants to wear branded clothes. And when people who are innovators here and who are trying to start their business, patenting may take a time. But you should be conscious and clear of what you want to make your brand as for the product or the services which you are giving. So what is a trademark? It is a mark which is capable of being represented graphically and which is capable of distinguishing goods and services of yours, one person, to those of other. So when we talk of trademark, we should have a good recall. A good trademark is the one with the good recall value. It should be distinctive. It should not be to the trade to which it belongs. What is your business? So many a times it so happens that the marketing team of a company and the legal team of a company, they'll always have conflict. Because marketing team will try to sell a product and keep a name which the audience can immediately relate to their product. But the legal team will tell, no, this is descriptive to the trade, so it's not a good mark. Just to say the Apple, earlier also we mentioned. Now, Apple you can relate to the computers or to the technology. It has nothing to do with the Apple. And that to the Steve Jobs, what he had designed was a half-bitten apple. So whenever you see, you know this is the Apple product. The moment you hear the Tata name, you know Tata Motors, Tata Steel, but when Tata came into grains, Tata Sampan, but you have that recall value that this particular company is reliable company, reputed company, so you tend to buy the products even if they are not pertaining to the, they have ventured new into the business. The trademark, you can file whenever you want to, like you have not used your mark, and you can still file it as on proposed to use basis, or you can file later on after the user, but you have to then disclose the user, file with an affidavit, which is also a good thing. Like patents, that once you have disclosed anywhere, you cannot seek patent registration. This is not, with trademark, you can even file later on. If you don't have a registered trademark, you can still fight out with your competitor or anybody using your trademark on the basis of passing off. Once you have registered trademark, you can file for the infringement proceedings. You can keep it perpetually alive by making payment, and the slot is 10 years. Every 10 years you make payment of the renewals and you can keep it, like Coca-Cola. It's still, everybody knows, it's still a brand. like it is a registered brand, so they can fight it off. The next is geographical indication of goods. I know the audience perhaps may not be interested in this, but still it is something to be reckoned with, and the government of India is trying very hard to give GI tags. What exactly it means, I'm sure all of you have heard of champagne, which was earlier known as the best GI, but now the Indian patent, under the Indian geographical industry, we have more than 567 GI tags which are registered by the Geographical Indications Registry. These are goods defined as that aspect of industrial property which refer to the geographical indication referring to a country or to a place where it is situated as being the country or a place of origin. Solapuri chadar, you will find Kolhapuri chappal, Darjeeling tea. So even the handicraft. So it could be either like basmati, which is originally or naturally produced or manufactured in that particular place. So when we know once you have a GI tag to your GI product, automatically the market value of that product increases because it gives a more authenticity. As sir had mentioned about the haldi latte, which has gone, and they call it golden, golden milkshake. We all were taking haldi milk every day. Anybody has any cough problem. So it is like that traditional knowledge was pervasive throughout India. No barriers vis-a-vis the social strata. Everybody was aware. I know, my bai knows. Everybody is aware of it. The term of GI, this is also, it comes closer to trademark. It is 10 years and it can be kept till you want to keep it, like perpetuity. Then copyright. This is a little complicated because it has bundle of rights. Unlike patents or this GI or design, copyright is, it subsists in following classes like original, it has to be original, literary, dramatic, musical and artistic, or cinematograph films, sound recordings, and the term is 60 years from the beginning of the calendar year next to the following year. This is little complicated in a sense. In the first A, in literary, dramatic and musical and artistic work, it is 60 years from the time the author has died, 1 year after the next calendar year coming. From there you calculate the date. Same with the sound recording and cinematograph films. It is 60 years from the date of publication, and the same criteria applies. And copyright is the longest, 60 years. That's why certain songs also you see, the Rabindranath Tagore's books also, it was a longer period for which you get copyright. Then semiconductor layout design. It means layout of transistors and other circuitry elements and includes lead wires connecting such elements and expressed in any manner in a semiconductor integrated circuit. The term is 10 years. So where you cannot patent, the process is not patentable, you can still get certain amount of protection under this. The Office of Semiconductor Layout Design Registry is at Delhi, Copyright Office also at Delhi Patent Office, and GI is at Chennai office. Patent Office is in 4 places, Mumbai, Calcutta, Chennai and Delhi, and Trademark Registry also in 4 offices plus at Ahmedabad. Now we'll go to the basics of the patenting process, some of which is already explained by Kulkarni sir. And to take you to the brief overview, like preparing specification, which he had said quite elaborately, filing application, publication, examination, you file response to FER, and then the hearing occurs, you file your written submission, either you will get a grant or you will get a refusal. Now, as I said, the patent offices are situated in these 4 places, plus, as you are now aware that you have to file territorially, so where you can file. So where either the applicant has residence or domicile or business, or invention is actually originated, and in case of foreign clients, where address of service in India is given by the applicant. You have to file an application in the appropriate jurisdiction. So you are staying in Mumbai, you cannot file in Chennai, but your application can be examined by the Chennai Patent Office. I'll come to that. Now, patent specification, the most important thing before filing is you must have your specification ready. So it is, as again explained earlier, techno-legal document, and the basic structure is title, the field, the background of invention. Now, what does the background of invention tell us? It will tell you that what are the problems you faced, why your invention is better than others. So you will take citation. Breakthrough inventions are very rare. Usually you make improvement to already existing, or you try to overcome certain problems which are already there, but now you have overcome. The gap between solving the problem of the prior art gives you a better feel, like it will be a good invention because nobody has solved till then. Now, then you explain the summary, then you give detailed description of invention. When you give detailed description of invention, means you must give the method in which the invention can work. And as earlier also explained, who is the audience for your document? The competitor is one thing, but in the legal terms we call him the person skilled in the art. So your electronics thing, if a pharmaceutical agent work, he'll not understand. He'll be as layperson as other. But the person who is skilled in the art, for him, he should be able to conduct that, carry out that invention. So he is your audience. You keep it, and so you make your document accordingly and try to plug in all the loopholes. And then when it is a chemical example, a biotech or chemical cases, you give number of examples supporting your claims. So when the examiner, because one of the criteria for checking out, which I'll come later, is that your claims are they supported in the description. So for that, and you put drawings if it is mechanical invention. You must have maximum drawing, which is explaining your mechanical features of your invention, be it ICE or any other thing you will have. So it becomes easy to understand and you can explain it. At times, they also put prior art also citation to drawing to distinguish that this is how it was in prior art, this is how it is my invention. So it becomes easy for the examiner to understand. And then you have abstract. Now, I was asked to dwell on this, the provisional. Everybody was interested when to file provisional application, and I think all of you are aware of it. So when to file? When you are, as he said, that your idea is conceived, you know, now I can file it. So what do you gain by filing a provisional application? You gain the priority date. And you get, patenting is all about timing and how to use the timing, and again, strategically, you should know how you should go around. So you file provisional before you want to market it, you must have, if you are disclosing, as he rightly said, that we have already got number of patents, application they have filed. When he says we have got, I mean you have filed provisional applications or maybe complete specifications. Now complete specification you can file at the time of filing application or later on. So when you convert your provisional to complete, you have 12 months. Now this first 12 months from the date of filing is very critical. In this 12-month period, you can go to anywhere around the world where you have, where you can file the application if they are not getting into PCT stage. In case those countries where you want to go, like to US or UK or EP, if they have, they are PCT contracting states, you can file PCT or international application, what we get. What does international application gives you? It gives you elongates the period of publication from 18 months to 30 or 31 months, but it also gives you a search report. And that search report you can gauge the strength of your invention. Nevertheless, coming back to the point, so provisional to complete, you get 12 months. And this 12 months, but your invention is yet not ready. You still want more time, but then otherwise it will go away. So your Patent Act gives you a provision for extending that period up to 6 months. That is still 18 months you can get. How do? You apply. You can apply as many times as you want. So you can seek extension of 1 day up to 6 months, because nobody wants to elongate dates so fast, because then you're losing priority, but you have the option. Second is, once your file complete and you are still working on the invention, now you wonder that, oh God, I forgot to put this feature, and this feature could have been very critical for my invention. If the 12-month period is not over, then you still have option to incorporate that. So you convert your complete to provisional, what you have filed, and then you file complete specification within that 12-month period. Once the 12-month period is gone, and if there is any novel feature, you can file patent of addition. But you can take advantage of this provision. Now, publication, automatically, if you're not seeking, it is going to occur in 18 months. From the date of filing or date of priority, here in India, we'll talk about date of filing only we have filed. Now, many a times the agents, they guide, we'll get it early published. So you pay extra fees for it and you get it. But what is the advantage? Unless you are clear that you want to seek early expedition of your patent, you want it. Otherwise, wait for that 18 months period. If you have what is the advantage that, suppose if you would have sought early publication, within 1 month patent office publishes. So you have filed your application, you are seeking early grant, you file next month, early publication. But when you have done this tinkering and you had the period of balance 12 months, now you can't change because your application has come in public domain. So now you can't make any changes. So patenting process is always a strategic process. Whatever you want to do, you consult your attorney and see the consequences of whatever actions you are taking and go ahead. The consequences of publication, these are the consequences. And secondly, it gives you, once it is published, it is open for pre-grant opposition. I'll come later on to that. Then you have the period of filing request for examination, which is 48 months from date of filing. Yet, if you want, the patent application will be examined only when you file request for examination, not from the date of your filing. So, if you want to file it, when you file complete, you can file request for examination. It comes into queue. Currently, there are 500 examiners, but there is a lot of backlog coming from the High Court of the patent appeal matters, but they are recruiting another 500, so we expect that it will have speedy disposal. As I said earlier, that the application has to be filed in appropriate office, but examination by the patent office can occur in a centralized manner. The reason being, a few years back, they made the 4 heads, like biotechnology case, chemistry, electronics, mechanical. So your applications are broadly distributed among those. So the examiner, whoever is present in any of the 4 offices, automatically the application goes to him for examination. Now when your clock starts ticking, it's when you get the first examination report. And that is the timeline very crucial, because now you have 6 months to comply with your deadline. You can get it extended by 3 months, provided you make that extension only once. It doesn't give you a chance again and again. Within the period of 3 months, you can seek it. What is the FER structure of it? It has basically 2 types of objection. It comes in 5 pages because their template is such. The technical objections are their formal objections. Technical objection is basically the controller will tell, he'll tell that it is not an invention, eligibility criteria not being satisfied, non-patentability, lack of novelty, inventiveness and utility, and non-patentability under section 3, which is we call the section of exclusions, where it could be an invention, but it comes under section 3, mere admixture, algorithms, computer program per se, traditional knowledge, you can't. And the FER will also give citations. So citations, they will cite the patents around the world, and they will also give you non-patent literature. Then there will be like unity of invention, as it was mentioned. If you have more than, I'll just take 5 minutes more. Yeah. So unity of invention, then you can divide your application, sufficiency, these are you can easily overcome, and formal objections such as, the power of attorney or assignment not properly recorded, and you do it. So you file FER response, you try to file in 6 months, if not, within 9 months, and then within a period of, depending on the backlog the patent office has, but very rarely I see it gets granted. You quite 90% time you get a hearing notice. Hearing notice is issued, and you again have an opportunity. The applicant has to get adjournment for twice, and when the hearing occurs, you try to set, the controller may cite now new objections, so new citations, or may continue with what is already stated. You comply with those objections, attend the hearing, try to convince him. If he is agreeable to it, it will go for grant, and you can get the feel of controller depending how your relationship is with the controller, you will know, or it will get refused. If it gets refused, it will go for, you can go for appeal. But when you will file your written submission, one should always file that in case if it gets refused, I should win the case in appeal. So try to put all your submissions in your written submissions. Then this is this entire procedure if there is no opposition. But then the pre-grant opposition occurs at the time when once it is published till the grant, as the name suggests, pre-grant. And it can be filed by anybody, any person. So many a times the competitor will put a dummy person and they will file the pre-grant, but it will be heard only when the application will be examined. So simultaneously it is heard after, and post-grant opposition is filed by a person interested. And for that, the pre-grant is heard by controller. For post-grant, opposition board is created. Then once you get the grant of the patent, within 3 months you can file, you get a time to file your annuities. And these annuities are like accumulated annuities because it takes little time to get the grant of patent. And then every year you keep on making payment, and you can always make lump sum payment also. Now coming to the cost is, this is my last slide, it is, or maybe one more, government fees and patent agent fees. Now patent office has recognized quite a number of more than 200, 300 patent facilitators, and they charge very nominal fees. So it is between 50 to 60,000, I think, overall for the entire cost. But the government fees for startup or individual is very, very low. It is almost like if you are paying 1,600 for per application, one invention, you are paying 8,000. If you are a non-individual, you are a corporate. Okay? Same way, the annuities keep on increasing with batches. So when you are paying the maximum fees you pay as an individual or startup is for 20 years or 16 to 20 years, which is 8,000. And by then, if you are other than that, you are paying 40,000. So there is great reduction for startups, or you can file as an individual, and you can get reduction of fees. As far as the private parties are concerned, private agents, the first major charge is when you draft the application and file, and then when the application is examined at that time. So which is around 1 lakh or so, it happens till the grant, or maybe more. And depending on how strong how complicated is your case. And so this is the advantage of it. And if you have a startup, you can avail expedited examination. And I think I have tried to cover everything in a very short time. Thank you so much. And thank you once again, CiiA, for giving me chance.
Thank you, madam, for all enlightening session and more about the minuteness about the patenting process. Because earlier two speakers talked about what the patent is, the importance of it, pros and cons, and here is the authority who could tell us about the minuteness of the process. I could see that some of you are taking the notes because this knowledge is coming to you because of these seminars like this. I request our Marathi Vigyan Parishad past Vice President and very active mathematician and a senior scientist, Vivek Patkarji, to do the honors for Karuna ma'am. I request him to do the honors with a fruit basket and a certification for active participation. Thank you very much. Now we have one more session to go with before we break for the lunch. I am awaiting Dr. Jairaman, and we will have it at 2 to 2:30. I think he is not in the hall. We will see it. And that session will be the last one before the lunch. And after lunch, we are going to have like a Shark Tank, the experts, where that entire session will be chaired by Nilesh Lele, who himself is here already, along with 6 investors, experts, and there will be 14 startups which are already decided who will present their pitch to the overall panel. So that will happen after a lunch break of 2:30 to 3:30. It will start at 3:30. So to summarize, we will have a break of 15 minutes now. 2 o'clock, Dr. A.P. Jairaman, a senior nuclear scientist, will start his session, 2 to 2:30. 2:30 to 3:30, we will have a lunch. And then at 3:30, 5 minutes before that, we will assemble for that 3 hours continuous session of the entire pitching by the 14 shortlisted startups. So see you at 2 o'clock. Thank you.
Hello everyone, my name is Bhavya Shah and I am from grade 8. When I will play tabla, the sound sensor will capture the sound created by the tabla, and the sound sensor will then send the sound energy to the Arduino Nano board. Then the Arduino Nano will convert the sound energy into electrical energy, and then it will send the electrical energy to these LED lights. So now I am showing how it will play.
We are from Social Service in Junior College. This is our project, Obstacle Avoiding. We have made this robot to prevent the accident, and also our aim was to make a precautionary instrument to prevent accident. So for that we have used a component like Arduino Uno, motor driver, Bluetooth module, ultrasonic sensor and a servo module. So the working of this model is that if the object comes in front of the ultrasonic sensor will detect it and it will move backward and it will change the direction. and it will move backward, because if the car will move front, then the car coming from the front will get crashed and the accident will take place. So to prevent it, first it will move backward and it will get from the side. And the feature of a robot is it works on 3 modes. First is autonomous, second is Bluetooth control, and third is vocal command. And if you want to implement this in a real car, it will cost less, because most of the components we are seeing here is very cost effective and we can be implemented easily.
My name is Rupa Solapur. This is my agriculture drone. It used to spray fertilizer over large agricultural lands. It has 3 modes. In first mode, you can control manually. Second mode, you don't need to control manually. In the third mode, if you think the drone is in danger, then you can land the drone immediately. It is a multi-purpose drone, and it's not a prototype, it's the actual product.
I'm Lakshya.
I'm Nehal.
I'm Sudesh. So basically, I just want to tell you that most of the Indian population is engaged in agriculture, and so does the farmers' basic needs are insecticides and pesticides, which are very harmful. So to prevent those insecticides and pesticides, we have created this model. I would like my friend Nehal to elaborate on this.
So here we go in the project. Our project consists of 2 solar panels, 2 batteries, a UV bulb along with the electric grid, a tray filled with water with oil droplets. So the solar panel converts sunlight into electricity, and the electricity is stored in the battery. The power of the battery is utilized by the UV bulb and the electric grid. And in the evening, when there is no sunlight, the insects get attracted towards this UV light and get electric shock, and they die and fall in this tray. Thank you.
Hello everyone, I'm Ravi.
Myself, Ruby. Myself, Princy.
We are from Matishri Kashmir and Motilal Patel Senior College of Agriculture. Basically our project is Instant Smart Home. A project works on the signal sends direct watch on vehicle stop. The signal green is for repeat positive. Vehicle start the signal is green, the barriers start up, and the signal red is for people stop and the vehicle start. This is for the traffic management and the people who don't follow the traffic signal. Thank you.
This is our formulation. It's an institute gel for which we are made. It has a three-way action and the inflammatory, anti-analgesic and anti-spasmodic. So that we have various parameters and what the optimized is. I can show the demonstration as this is depiction of vaginal pH, and our formulation after entering into the vagina, after coming in contact with vaginal pH, within 2 to 3 seconds it gets converted into gel, and the gel adheres on the side linings of the vagina and gives its effect. You can see the same via our tools, also with the backplate and the flame. We further try to go for the bioplastic packaging for its total eco-friendly and green use. So finally, the parameters show that its optimization is very good and with as compared with the standard.
Can travel outdoor as well as indoor within the campus. Hence 25 km per hour. Requires no license and registration. It gives 35 to 40 kilometers range, so it can be traveled within the 20 kilometers radius, and it is completely foldable and can be carpet. So you can travel outstation also. There is no other vehicle in the market like this. So thank you. Appreciate your interest.
It's an insect herbal repellent cream which is based from herbal formulation, and it is used for sustainable release of bioactive compounds. It consists nanoparticles which increases the surface area and increase sustainable release of bioactive compound and increase penetration.
A, vitamin B complex, vitamin C, vitamin E, vitamin K. Targeting marketing information, targeting health conscious people. Malnutrition cases below the poverty line. Targeting the natural plants, targeting in the government schools, primary health centers, medical stores, activities.
NEPA, habitual remedy. NEPA is the basically natural efficiency air purifier, which purifies the air, converts carbon dioxide to oxygen. So basically, there are several algae like red algae or brown algae or green algae, but we are using the Indian origin algae, which converts carbon dioxide to the oxygen in a more efficient way than the other algae, and it also uses the harmful substances like nitrogen, sulfur, or carbon. Potassium like substances to growth catalyst like, and also it requires essential nutrients which are also harmful substances. So this basic principle is algae plus water, and the algae needs the harmful substances to growth related. So it can go into the recycled water also. After the uses of the algae settle down inside the water will become wastewater, and after recycling the water we can use for reuse for this algae. So this algae is having a high concentration growth factor in recycled water also.
Namaskar, good afternoon. The next seminar, what we are going to have is from another eminent senior experienced speaker. Let me welcome Dr. A.P. Jayaraman, the person who carries 40 plus years of experience. He is a senior nuclear scientist at Bhabha Atomic Research Center. He is a president of STEAM Academy. He is a principal scientific advisor for HSNC University. He is a chair for National Center for Science Communication. One of the characteristics, if I can say, as a specialization of Dr. Jayaraman, he is a fantastic science communicator as a bilingual in English as well as in Malayalam. He is a PhD science. He has also done his PGDM, postgraduate diploma in management. His specialization, as I said, is in atomic energy, in science and technology and management. He is a professor of environmental engineering at Singapore. He is a dean at B School in Palakkad, that is in Kerala. A fantastic science communicator. So let us experience that communication from Dr. A.P. Jayaraman, sir. Please, sir.
Good afternoon, all beautiful minds. I have been introduced as a communicator, so my business is to speak and not do anything. Full of thought and fuel signifying nothing, there is what is this. So I'll make some noise. But if you can find some voice in the noise, that's what it is. I am giving example of an innovative inventor who has not made money. This is very important for me to share because my father was an innovator and he did some innovation which is striking today. He was making knives, scissors, and scissors are black in color, black engineers. So he has to be painted, electroplate, and electroplating was done by nickel. And the coating of that nickel, how beautifully you prepare the surface. He used to clean it wonderfully well. But then he found out that if you coat nickel on steel, if you can superimpose copper first and then nickel, it will have a lasting effect of 10 years. So my father's knives didn't peel off their color for 10 years. He had a competitive advantage of electro-depositing copper on steel and then do nickeling. That's the beauty he did. We did it, but we didn't make money on that.
Now, innovation means doing something which is different. It also means doing in such a way that you make money. So let us look at another aspect of innovation. Imagine you are going to have to be a coffee producer. And coffee is produced from coffee beans. You can make either plantation or robusta. If you grind the coffee and you are going to add, you can sell it as such and at some money. Let us say we are selling at 50 rupees per kilogram coffee powder. Now you take tamarind seeds, de-shell it, take the shell, same color density as that of coffee, add it as an adulterant and you sell it. You are an imaginatively successful innovator. You have not added any toxic component to it. But at 5 rupees per kg, 50 rupees per kg is the Robusta coffee. If you blend the two, you are going to make a lot of money. Now here comes ethics. Shall I add tamarind shell powder to coffee and make money? I'm an innovative man. I may pass through the food test because I have not added any adulterant, because it's not by definition an adulterant. So that's what it is. Or imagine you have turmeric with you. To turmeric you add methanol yellow and it will look beautiful well. You can add starch, you can add sawdust powder, or you can add calcium carbonate. So addition of a chemical to another value chemical with a less one and appearing and passing all the tests, you will be one of the finest innovators. Shall you do it or shall you not do it? If you are an inquiry-based scientist and if you are interested in reaping money fast from the low-hanging fruits, it's necessary for you to go through some of these routes. I am not advocating for it, but I am saying this, the route is very, very large for that. Can anybody? Yes. We are all under the erroneous impression that if you don't do good R&D, we all say that in any classroom, every lecturer will say you are in a K economy, you are in a knowledge economy, and if you don't do absorb knowledge, not only absorb it and make it integral part of your living thinking system, it is not possible for you to do any innovation. Now, if R&D is the DNA of innovation, then look at how do we do R&D. You can do small r and small d, a little of this and a little of d. Know a little, do a little, come out with an innovation. Or you can have a huge knowledge, you spend in the library 1 year, and then you come out with some small idea and do a little development and come out. That's a capital KKD formula. Or you can do very small research and you can blow it up into disproportionate proportions and then come out. But the ideal R&D, as Bertrand Russell said, is the one where K and D are equal. You need a capital K and a capital D if you are to survive in an economy competitive market. So if you look at the R&D which is being done by the entire sector today, is largely done by the governmental institutions. I have a friend of mine from UDCT, sir, that he spent 40 years developing absorbent carbon. 40 years. And when he retired and we went into his laboratory, we found 1 kg of absorbent carbon kept. The problem was the scientific mind is not a sufficient and necessary condition for doing an innovation. I want to repeat this in the presence of the august presence of Dr. Joshi, that scientific mindset is not the necessary and sufficient condition for doing innovation. The reason is you can go on with the scientific mind. You can see so many aspects, as my friend who made absorbent carbon in our laboratories. He took coconut shell, burned it, got some powder. First he took it from the Bombay market, then he took it from Shalapur market, then he brought some elsewhere. The silica content was varying every time. He was not able to get a consistent product out of coconut shell as a result of the sourcing he employed for this. So if you do that scientific bent of mind, you will never be able to reach anywhere. So that is why an engineering mindset, an ability to produce with a timeline, a product with its specifications, we should be able to come out, and therefore you need an engineering mindset. This is exactly the mindset which is being created by the International Baccalaureate system of education today. You will look at the top schools of Mumbai, from Dhirubhai Ambani onwards. They have a profile for a student. That's a 7-colored segment, in which the first one is inquiry-based learning. Knowledgeable. Knowledgeable comes after inquiry-based learning. So if you look at the profile of the teacher and of the student of the Ivy League international baccalaureate schools, you will find they're exactly adapted for being competitive innovators in a competitive world. Now, this is very important because when they go to Ivy League colleges anywhere in the United States or wherever, they get into straight to the mainstream of innovation. The university provides the angel fund for that. And within 3 years of their graduation, they should be able to get the return ROI on this and pay it back to the university. So here is a compulsion in the educational system in one segment, but this is too narrow, 0.001% of our educational population. That is what is happening. So I have sold 2 points. Scientific mindset is not the necessary and sufficient condition for an innovation mindset. 2, an engineering mindset is absolutely essential as far as innovation is concerned. And the larger you have an engineering mindset, the better for you. So this is a standard definition which any professor will give you when the class starts, right? That innovation is a process by which a domain, a product or a service is renewed and brought up to date by applying new processes, process upon process, introducing new techniques or establishing successful ideas to create a new value. I must share with you an experience I had when we developed a membrane called cellulose acetate membrane. We were the first to make in BRC at that point. It was an old story of the 70s. So to make a cellulose acetate membrane, that was something new at that point of time. And to treat water, brackish water, that's about 5,000 parts per million, that has to be treated and we had to give drinking water. So we did the process. We brought out the product cellulose acetate. There are 3 steps: research, development, demonstration, and deployment. RD3 is the code formula for BRC to do a product to the market. So D, the second D, research and development, demonstration. So we were asked to demonstrate this product as an innovative product in the villages. We did it in 2 villages. And as we were collecting water from the brackish well and treating it with cellulose acetate membrane, and being sold to the villagers for drinking, sold means free, they found out that we were adding sulfuric acid for pre-treatment of the water. This was carefully noted and the news went around that water is being acidified for sterilizing the people of the village over here. When you are bringing a new product into the market, there are consequences, unintended consequences, totally unconnected consequences arising from the act of the process. So any amount of your selling the truth that acidification of the water for pre-treatment is not the objective, nor are we planning for sterilization of the people over here. So that's one of the very interesting stories we had when we introduced cellulose acetate brackish membrane treatment water. So in large establishments, in large R&D establishments, you don't find innovators per se. Because the reason is government pays your salary. And your salary is safe and secure as long as you do not violate the official rules. If you can take leave properly, respect your boss, keep your good relations fine, you will never be thrown out. You don't have to be innovative. But you will find some of the finest minds, some of the most beautiful minds, extremely innovative. And when they do innovation, they go out. When they do it properly, they will go out. So if those entrepreneurs who are dreamers who do, but those who take the responsibility of creating an innovation of any kind within an organization. Now you take an organization like Deloitte, or you take an organization like PwC, you will find that every soul in the PwC is an exceptionally brilliant, sharp mind. And everyone is an innovator by himself. How to keep a group of innovators together? That is the problem of innovation which PwC needs today. So therefore all of them will go out and you get a chain reaction of this type. So centers of excellence create chain reaction by enriching the value of each member of the organization. Now this is the standard one which you can from the textbook. I am not going into that. The metaphor here is a seed. because there's a biological metaphor which helps us to explain the concept of innovation at this stage. But when the tree is cut and when the timber is sold, and the planter should know that the tree is going to be cut. The murder your darlings, that's what we say. You have an idea, you have an innovative idea, you have developed, nurtured it, sustained it, brought to its highest point of strength, and you have to cut it and murder it. And that is the most painful, poignantly sharp point in an innovator's life. But we should be prepared and do that, sell it. This is where the highest business acumen today is being used. Deal assistance in financial institutions. To be a deal assistant in one of the financial institutions is the highest paid job you can think of. And technology deals, how to evaluate them, how to assess them, and how should I sell my company and what price should I buy that. That is the technological deals, and some of the finest, highest paid jobs in innovation are those who know innovation, those who know the value of innovation, those who know the expanding lifespan for an industry. After 5 years it will die, but within 5 years how much money we can make. So that type of calculations are done by deal assistants in financial institutions, so they will have a thorough knowledge of. Okay, this is one of the finest definitions I have found from the Harvard business professor, and Professor Stevenson always says, entrepreneurship is the pursuit of opportunity beyond resources control. In this few words, you have the entire psyche of innovation controlled. It's the pursuit of an opportunity. The opportunity doesn't exist. For example, there is a $23 million sanitary pad manufacturing process now available from NASA. And no innovator has succeeded in getting it, because when the astronauts go into space, urination is a problem. It's one of the highest problems. That $23 million has been set apart for innovators in the United States to develop an appropriate absorbent system, or an engineering system which can retain the urine, or a reverse osmosis system where the urine can be converted into potable water, safe potable water. That's a challenge for them. So innovation doesn't mean tinkering as we do in our laboratories. Again, we find in the name of innovation there is a lot of fashionable, extremely fashionable, high superstitions wandering around. Innovation means buy a set of electronic gadgets from Korea or from China. And if you have the robotics revolution taking place, I'm not against the robotic revolution, but if you go and wander around the innovation sets, all of them will be devoted to robotics. They have a value, and they will tell you the criticality and the essentiality and the vitality of the process they need. When you look into chemical processes, physical processes, or biological process and biotechnology, you will find innovation is the least. Of course, there are 100 women innovators of this country who have shot into international fame, and they have done a very great job. So coming to the startups it is home. We are home to 1/3 largest startup community in the world, and all of us will speak of unicorns. When you think of a unicorn as a $1 million industry, unicorn never existed, neither a horse. It's a hybrid of a horse and a goat. Now, these are the metaphors which we are chasing. But if you look at the history of innovation during the last 200 or 300 years, 1885 there was a peak. And beyond that, there never has been a peak. We have been producing small ups and spikes on that, but we have never been able to do fundamentally a game-changing innovation after that. Okay, that's one. Well, this is again for MBA students. In fact, it is easy to lecture on innovation rather than do any innovation. And George Bernard Shaw put it nicely, those who know they do, those who don't know they teach. So that's precisely what I am doing now. We can speak hours together on clear value proposition, on proposition, value proposition, and clear proposition, 3 aspects of it. Then you can speak about market research and understanding of that. Market research, CiiA, GR should be calculated. Imagine hair dyes. Now, hair dye industry in India, I hope Dr. Barve will excuse me for mentioning that. If you look at it, if you do a research, and research means search in the literature, stops there, we don't do anything. And it happens which portion of the literature comes up to your sight. So you are conditioned by what you read. Now, market research is available for everything. Right from hair dyes with vegetable components and with synthetic components, and also suitable for men, suitable for women, and suitable for fashionable women. This is a segmented market on that. Now, if you know the market size, and if you know the compounded annual growth rate, do you think you will innovate into that and get into this? You have to do that. Then again, gone are the days of glory when a solitary innovator comes out from the sky and says, I know about it, take it from me. You have to do teamwork. In fact, averageness is attractiveness as far as innovation is concerned. A brilliant fellow will not produce an innovation. If you look at the contemporary status of the space department, you will find that most of them are average engineers. If they had been exceptionally brilliant engineers, they would not have done the work. In fact, it is counterintuitive for me to state that averageness is attractiveness in the innovation profession. So don't be exceptionally brilliant. Then you must have that ability to get along with your colleagues. Our egos are so sharp, and fundamentally we draw a polarization line. I cannot get along with him. In fact, none of us can get along with another source. This is one of the biggest problems in Indian innovation. Put 2 or 3 together, you'll get an antagonistic effect. But you put 2 Chinese together, you get a synergetic effect. We are notorious for our antagonistic effect. So strong team culture is required. The Japanese culture, the Chinese culture, where they are fundamentally tuned to this frequency of working together, fine. Now, you must also have that capacity not to be conditioned by or gravitated by your earlier thoughts. You should be able to change very fast, and you should be able to adapt to the available conditions. So this is what is expected from, above all, financial management. If it doesn't bring money, if you are making a loss-making proposition, don't stick on to that for a very long time. So you look at the FANG theory. You have the Facebook, Amazon, Apple, Netflix, and Google. There were innovators. Nothing existed where they came. So if you look, you can have a number of technologies. The felt need of the society, market size, total volume required, logistics management, financial management. That's a big thing. I've told you about all of those things except the last one, gold from seawater. Now, if you want to make gold, and you know that parts per billion level of gold is available in the seawater, and you start with a desalination plant, so somewhere like Bhavnagar, and you get chemicals from that, and from that residual chemicals you start making the seawater. Then innovators, alchemists of the Middle Ages were also innovators. They tried to convert lead into gold, and they never succeeded. All alchemists were trying to make a philosopher's stone or an elixir of life from which base metals should be converted. Any amount of innovation, you will not be able to change the atomic number of lead into gold. So your next innovation step is, what I'm trying to say is there is a knowledge map corresponding to that. If you don't do your knowledge exercise correctly, everything will appear absolutely attractive, making gold from seawater. What more can you do? No cost, infinite amount of raw material. All that you need, an exchange resin which should be able to preferentially absorb. But the problem is 35,000 ppm of sodium chloride is present, and that will saturate your membrane. That is why I said the scientific mindset will not let you have a great innovator. You need an engineering mindset. With that, I stop my formal sound making. And if you have any questions, I have been dabbling with this for about 40 years on innovation, trying to do and failing every time. And the failures are more successful than the successes themselves. I am open to criticism. Yeah, I am here.
I could say that, this was a really walk when you talk, an interactive session. Typically, as you know, the alphabets of A to Z, if we number them from 1 to 26, aptitude amounts to 96, the total of them, but attitude makes 100%. And I think Dr. Jayaraman's speech refers about refinement and calibration of the mindset and mind frame, what the innovators and entrepreneurship could generate and challenge his own status quo. Thank you very much for that insight. I request Marathi Vignan Parishad's Secretary, Karyavaha, who is here, Shri Appa Deshpande sir, to do the honors for the guest speaker. Appa Deshpande sir is 50 plus years a science communicator, basically a civil engineer. He is also going to have a session with us in these 2 days. Always we say that age is just a number. He is 81 years young. And he is the walking, talking encyclopedia of our Parishad. He has hundreds of books and thousands of articles. So right person to do the honors. Yes. Sir, the certificate of his active contribution to these seminars. Thank you very much, Sharmaji. You should be very happy, I'm sure. If you look at your clock, we are at exact on dot 2:30. Yeah. So we will have, as per the schedule, it is because of all collective efforts, as Dr. Jayaraman said, that it is cohesive work. So 2:30 to 3:30, we will have a lunch break as per the schedule, which is being published. 3:30 onwards, the team of 6, I will call it as a mentors, angel investors, assessors, they will have, kind of an interactions with 14 startups, like on the model of Shark Tank. And that will start at 3:30 to 6:30 at the same place. And we will see each other again at 10 minutes before 3:30 so that we do a setup. So right now it's a time for a lunch break, unless Sharmaji has something to address.
No, I have just to appreciate the way actor is leading the whole seminar. So I think big appreciation.
No, sir. My duty. So we will assemble again at about 3:25. It's a lunch break now. And I also encourage you to take a round and encourage these budding entrepreneurs who are also waiting for you to witness and see their some exhibits. See you soon.